I'm Jamie Hendricks. I'm the estate planning advisor here at Capital City Financial Partners. I want to thank every single one of you for joining into this webinar today. If you guys have any questions throughout the webinar, please feel free to put them in the chat and I would love to be able to help answer them. And if they're very specific, I would love to be able to schedule another time to sit down with you and talk about all of your questions. So today we're going to be diving into estate planning and healthcare planning. I know those are really fun topics to talk about, but before we kind of really dive into it, I kind of want to give you an insight of my background, how I ended up here at Capital City, and why I have such a passion for estate planning. So I have a feeling that most of you are a lot like me. You all have a million things you have to do every single week, and we all struggle just to get the bare minimum done. We all know that there's certain things in life that are important to do, we need to do, but life has a funny way of getting in the way. I have found during my career that estate planning ends up being one of those things. We all know it's important, we all know we need to do this paperwork, but life has a funny way of getting in the way, and we keep telling ourselves we're going to get to it next week, and then next week comes, and we didn't get to it. So Capital City and I like to tell our clients here that estate planning is more than just the paperwork you have to complete. Estate planning is how you protect you, your family, and your legacy, and especially protect all the assets that matter most to you. So, okay, I messed up. You'll be able to edit this?
Yeah, but you don't.
So as we get into it today, I want to first start with wills versus trust, and then we're going to lead into some healthcare planning. So as you can see on the slide, there's a lot of differences between wills and trusts. I always like to tell everyone that each one of these options are not better than the other. They're just different tools and different mechanisms to get to a similar end goal. So first, I'm going to kind of dive into wills. With a will, your will only becomes in effect when you pass away. So there's really no lifetime mechanism that allows you to control with a will. It really only covers probatable assets, and its limited purpose is dealing with your estate planning. And also with the will, this is where you will nominate, if you have minor children, a guardian who is an individual that would step up and take care of your children if something were to happen to you. Because a will goes through probate, it's a matter of public record. So there's not a lot of privacy protections with the will. So once your will goes through probate, it is to the public eye, which means it's easier for creditors to discover your assets. In South Carolina, creditors have about 8 months from the time you pass away to make a claim on your estate. So typically the probate process in South Carolina is taking a little over a year. There are some abilities to override a will. Sometimes private settlement agreements can override a will, divorce decrees can override a will, and there's some exempt property claims and elective share claims within the law that can override your will ultimately in the end. Now moving forward to a trust. A trust is effective immediately upon funding. And you might be wondering, okay, what is funding? So funding a trust is actually the process of moving assets into the trust. Part of the trust, the first step is you have to create the trust. And then the second big part is you actually have to fund the trust. And a trust is actually cool because it has abilities to control assets during your lifetime that you move into a trust, but it also has the ability to control assets that are moved in the trust after you pass away. It can also be used for incapacity planning, tax planning, and asset protection. And generally it's a private document, so it's harder to find. It doesn't go through probate the same way that a will goes through, which means it's harder for creditors to discover. It's not impossible, it's just a little bit different of a process. Because a trust is a lot more set in stone and a lot more goes into making this document exist, there's a lot less opportunities for a trust to be overridden. But with a trust, this is not the avenue you're going to want to take to nominate a guardian for your minor children. So as you can see, both of these documents have a lot of cool advantages, and most times these documents work together hand in hand. You're typically not just going to have a trust and not a will, but both of these documents are great tools, and one's not necessarily better than the other. They just serve two different key purposes. So for my visual learners, I have a little chart here that you can look at. So as you can see, the more that your plan is a simpler estate plan, you're going to usually have more probate involvement, less control over your assets, and then it's less expensive. where the more complicated your estate plan gets, that's when you usually have less probate involvement, more control over how your assets are divided, and it's usually more expensive. And also for my visual learners, I have a little chart that you're going to get to see of kind of how wills work. So this is a very simple will, but as you can see, you have your will. If your spouse is surviving upon your death, then typically everything that's in your will is going to go to your spouse unless there's other restrictions in place. If your spouse is no longer living at your death, then typically everything's going to go to your children or other designated beneficiaries of your choosing. So this is where a will gets a little more complex and actually intertwines with a trust. So now you have a will, and so then with inside the will, you can create a family trust or a marital share, depending if that's needed. And then at your death, if your spouse is still alive, then the trust can decide if assets are going to go to your children outright or they're going to go into the trust for a trustee to manage and then divvied out appropriately per the trust rules. So as you can see, these documents really intertwine with each other, and you can have one, like a will that leads into a trust, and that trust can manage the final assets and how the final division is to go. So you might be wondering, okay, what are probate assets? So I want to kind of go back to probate in South Carolina and explain further what that really means. So probate assets are either controlled by your will or controlled by the laws of intestacy, which means you've died without a will. So typically, any assets that are going to go through probate or any assets that are left in your sole name upon your death. So these could be bank accounts, cars, property, whatever is solely left in your name upon your death. However, if these bank accounts or retirement accounts or investment accounts have a designated beneficiary or a pay on death clause or transfer on death clause, then those assets will not go through probate because they're going to go to the beneficiary listed. This is the same for retirement plans, life insurance, or jointly held real estate. So no assets will go through probate if those assets are going to someone else. It's the assets that go through probate are solely left in your name upon your death. Or, of course, if any assets are going to the trust, then those assets will not go through probate. So to dive in a little bit further, we've already kind of talked about a couple of this, but if you are not really interested in a trust, but you really want to avoid probate, there's some key things you can do to accomplish that. So like I said, if you name beneficiaries on your IRAs, your 401ks, life insurance, whatever it may be, the beneficiaries are going to get those items upon your death. They will not have to wait for those items to go through probate and be approved by a judge. Again, with the transfer on death and payable on death, if your bank accounts allow you to have these set up, it's important that you do because it's one less step of assets that have to go through probate, and especially if you're leaving a family behind who are responsible for paying bills, them being able to access that money very quickly can make a life-changing difference, especially in a time of a lot of stress and heartache. So something I would like to talk a little bit more about is a concept called joint tenants with right of survivorship. I'd be willing to bet most of you who have bought property with another individual have a deed that's written up with this kind of language. And the purpose of this language is that, say, I was to pass away, but my husband was still in the home. He could still live in the home during his lifetime, sell the home, refinance the home. He has equal rights to that home, and he's not basically homeless waiting on probate to allow him to live in the home. So sometimes people think, okay, this is great. We don't have, our house doesn't have to go through probate upon the first spouse's death. So why don't we add a child to our deed so we can skip probate altogether? Now, that is a concept that can work great for some families, but it can be disastrous for others. When you add a child to a deed, you lose something called a step up in cost basis. So I am sure a lot of you today were probably lucky enough to buy a house for $100,000, $1,000 back in the day. Now that home may be worth $500,000. When an individual is inheriting that property, they get a step up in cost basis, so they don't have to pay capital gains tax on that growth. And as you can imagine, a home worth $100,000, now worth $500,000, would have a huge capital gains tax bill. Your child inheriting that home does not have to pay that tax bill, which is a huge advantage. When you add a child to the deed, you lose that step up in cost basis. So your child will be faced with a huge tax bill. So that can cause a lot of problems for families who are not ready to pay that bill. Additionally, when you add a child to a deed, you are opening up your home to their debts, their lawsuits, and their divorces now, because now they have property rights into that home. So we have seen it happen before, and it's a heartbreaking situation where a child was added to the deed and now that child is going through a divorce, and now your home can be pulled into their divorce. Additionally, when you do this, it also opens up your child to have the ability to tell you no. If you're wanting to refinance or sell your home, your child now has a say in that decision, which can kind of cause some problems with family dynamics. So this isn't trying to tell you not to do this, but there is some negatives if you choose to go down that path. And obviously, if you want to avoid probate as much as possible, if you transfer as much assets into a trust as possible, then those assets will not go through probate. So now I want to spend a little bit of time talking about trusts. So with trust, there are many different types of trusts. The trusts are getting very creative and very helpful for estate planning. So to kind of make this easier to understand, it's easier to think about trusts in really two main buckets. You have a revocable bucket and an irrevocable bucket. So with that revocable bucket, like its name, you can amend or revoke your trust during your lifetime. It's not a separate taxable entity because essentially you still have control over all the assets in that bucket. So you don't have asset protection there, and it's still part of your taxable estate. So you don't have to have a different EIN number, taxes are filed under your name, and you're able to put trust assets into the trust, but also remove the assets if you feel that's best. With an irrevocable trust, it is very permanent. You can revoke and amend during your lifetime, but it typically involves court involvement to do so. And that's because when you're moving assets into an irrevocable trust, they're no longer really counted as your assets, but it gives ultimate creditor protection, tax protection, and asset protection if it's structured correctly, because those assets are really now out of your name. But with that, you typically have to file separate tax returns, and there's a lot of other more complications that go into it. But both of these trusts are great tools. They each serve different purposes, and most times people are going to have a revocable trust and possibly down the road and also an irrevocable trust for certain assets. It's typical to have both of these or just one of these in your lifetime. It's not required to have both, and they both are great tools and just serve kind of different purposes depending on the needs that you have for your specific situation. So I know we have talked a lot about estate planning so far, but I also want to spend some time talking about healthcare planning. A big part of estate planning is protecting your assets when you're no longer here, but also a big part of estate planning is protecting you while you're still here. If you were to become sick, disabled, or incapacitated, decisions are suddenly going to get very stressful and very hectic for your family. And if you do not have a plan in place, your family is going to scramble to figure out how to pay for your care, who can legally make decisions upon your behalf, and what kind of decisions for medical care you even would have wanted. So, and also at Capital City, we also focus on how to pay for long-term care costs. We want to make sure that you're not wiping out a lifetime of savings just for a few years of long-term care. So I want to show you guys just some examples of cost with assisted living and in-home care. This was 2024 numbers, but it's only getting more expensive, unfortunately. So in South Carolina, living in a living facility is about $62,000 a year, and that's typically when you're sharing a room with somebody. And then even at home health is even more expensive. And then nursing homes are getting a lot more expensive, whether it's private or semi-private. And typically women are finding themselves needing about 3 to 4 years of long-term care, where men are about 1 to 2 years. So as you can imagine, you can really eat up your lifetime savings very quickly if you found yourself needing some sort of long-term care. So you might be wondering, okay, what are my options to pay for long-term care? And when you're paying long-term care, you're not really taking one approach. You are also going to be kind of taking a hybrid approach to this matter. So it can be a combination of self-funding, annuities with long-term care rider policies, or life insurance, or some kind of combination of all of these above. Now, I know you might be saying, okay, well, I'm not a huge fan of annuities or another insurance I have to pay for when we pay for everything else. And I kind of always like to equate it to home insurance. We all know we pay so much money in home insurance every year, and the premiums only seem to be going up. But we know that if something were to happen to our home, because we've paid all this money, we should be getting a whole new home rebuilt. And that gives a lot of peace of mind and a lot of clarity to people, knowing that their money is going to go to a purpose. Now, we all hope we never have to use that money and use our insurance like that. However, if we have to, we know we're protected. Long-term care is very similar to that. We all want to pray and hope that we don't end up in a situation where we have to go to assisted living or have to go to a loan home for 4 to 5 years. I'm sure that doesn't seem ideal to many of us. However, we know that if we are in that boat and we do have to go into these facilities, we know that our lifetime savings is not going to be wiped out to pay for this care, or our family's not going to have to step up and help pay for this care. So it is one more thing you have to think about and set aside money for it every month, but it really can benefit you in the long run if you start setting aside the money now versus really, unfortunately, having to wipe out most of your savings if you found yourself in this position. So a specific kind of irrevocable trust I want to talk about today is called a Medicaid Asset Protection Trust. And this kind of goes hand to hand with estate planning and healthcare planning. And this is kind of a key example of why you want to start thinking about your estate planning and healthcare planning so far ahead, because a trust like this has to actually be created 5 years before you go into long-term care. So this requires a lot of discipline and a lot of time set aside to sit down and really think far ahead so you can make sure your future self is protected. So the idea behind this trust is this: Medicaid will help pay for your long-term care costs, but only after you spent the majority of what you own. And I don't know about you guys, but it's not a great deal if you have to spend everything you have just to get a little bit of help for your last couple years. So this trust was kind of created where it's a special irrevocable trust, and if you move your assets into the trust and fund the trust correctly and the trust is completed correctly, you will essentially have your assets protected after 5 years, and those assets will no longer be counted as yours for Medicaid purposes. So Medicaid will look at your assets and determine, okay, you don't have as many assets, we're able to give you X amount of money now for long-term care. This can be a great tool because it also allows, if you're moving a lifetime savings account or a home into the trust, you can still live in the home during your lifetime, and after you pass away, your spouse can still live in the home. So this is a huge advantage to being able to use this trust, and you don't have to worry about having to sell your home or deplete your savings account for paying for long-term care. But again, this is a really good example of why you have to think ahead, because this isn't a trust you could create 6 months before you're thinking you need long-term care. It has to be created 5 years out because of that 5-year look-back period that Medicaid is always going to have. So this is just one example. This is not a great idea for everybody, but this can be a really powerful tool for certain people in specific situations. So as we really wrap up today, I want to take a moment to reconnect everything we've talked about. As you guys know, here at Capital City, we focus on 5 key areas. We focus on retirement planning, investment planning, tax planning, healthcare planning, and estate planning. All of these 5 areas are not separate pieces. All of these 5 areas come together, and if one piece is not working right, it is negatively going to affect the other pieces. So that's why it's so important to us here that we're all making sure that all of these pieces are moving together in the right direction to make sure you're protected and your family is protected. As you guys know, we have a wonderful team here at Capital City, and our advisors specifically are great experts in all these fields. But we can't be the expert in every single field. So this is why Josh here at Capital City has created such a wonderful team where we all come together, we all work together and make sure you're protected in all 5 of those areas. I know estate planning can be very overwhelming, and it can be very easy to say, I'm going to get to it next week or next year, and life gets in the way and it's not done. But it is so important to make sure you have an estate plan in place, because if you don't have something in place, your family is going to have to step up and make a lot of hard decisions, and it is really beneficial for them to have clarity when you're no longer here to give them that clarity. As you've been watching this webinar, if you have kind of found yourself having a lot of questions or now a lot of worries or anxieties, and you really haven't had time to really dive into your estate plan, Capital City and I would love to sit down and really work with you to make sure you understand your estate options, your estate plan is organized, and your estate plan is going to accomplish the goals that matter most to you. Again, if you have any remaining questions, please feel free to put them in the chat. I would love to sit down and make an appointment with each and every one of you to really secure your estate plan and make sure you have no questions or no lingering worries that are out there. And I want to thank all of you again for watching today, and I look forward to getting to talk to you all very soon. Bye!